I want to say that I believe in the rule of law. Our ability to address grievances in a civil manner in the court of law is fundamental to our freedom as Americans. Our jury system is not perfect, but it works, and certainly a hell of a lot better than most other countries in the world. The lawyer I'm going to be talking to is an excellent trial lawyer who cares about helping people and making sure that they get a fair shake. The opinions and statements expressed by our guest, Andy Baldwin, are his alone and do not represent the views of Allison Limontes, Hurst Limontes, Circle City Conversations, its producers, or sponsors. This miniseries is intended to share their story. Welcome to another episode of Circle City Conversations, and welcome to a very, very special three-part miniseries. In this three-parter, we take a closer look at one of Indiana's most tragic and complex cases, the Delphi murders of Abby Williams and Libby German. We are joined by Andy Baldwin, the attorney representing Richard Allen, the man at the center of this case. In this first episode, we explore the prosecution's claims, the controversial evidence, and the lingering doubts surrounding what really happened on that February day in Delphi. From the image of Bridge Guy to the theories of ritualistic influence and questions of physical possibility, the case remains layered with uncertainty. For a broader perspective, you can also watch the Hulu special, Capturing Their Killer, The Girls on the High Bridge, which features attorney Andy Baldwin and helps paint a larger picture of the Delphi murder saga. Welcome, everyone, to Circle City Conversations. Thank you for joining us for our conversation today. Thank you to our sponsor, Hurst Limontes, an Indiana law firm representing injured Hoosiers and their families for over 50 years. I'd like to thank everyone for tuning in to the first part of a very special series here at Circle City Conversations about a case that has made national headlines for many, many years now, the Delphi murders case. And we are joined by none other than Andy Baldwin. Can I call you Andy on the air?
Yeah, I tried to make Andrew work when I was a young lawyer. It sounds more professional, but Andy is what ended up sticking.
So, Andy's an experienced and an excellent criminal defense attorney. He's board certified. There's a lot of requirements that come along with that. Means you got to try a lot of cases, spend a lot of time in the courtroom. And Andy had the fantastic opportunity to represent Mr. Richard Allen. Andy, thank you for being here. I appreciate it.
Thanks for having me.
So Andy is the founding partner of the Criminal Defense Team, which is an Indiana law firm representing people who have been accused of crimes. And I've actually had the pleasure I worked with two of your partners. Yeah, Max and Kathy, and when we were at the PD agency almost 20 years ago, and we were baby lawyers back then. Yeah. So they are both fantastic trial lawyers, and we're here to talk about the Delphi murders case. But before we get into that, I want to introduce our audience to Andy Baldwin, and I want them to know a little bit about who he is, what he does, and why he does it. So let's talk a little bit about you. Tell us where you're from originally.
I grew up in Brownsburg. I graduated high school from Brownsburg in 1985, and then went to college in Franklin College, which is a little tiny college south of Indianapolis. There's about 400 people there when I started. And then I went to law school at the University of Akron in Akron, Ohio. Often get asked how I ended up there, and my answer is always the same. I wanted to be a lawyer. I applied to 10 law schools, and one law school accepted me, and that was the University of Akron. That's how you end up in Akron, Ohio. I did a little DJ. I worked for some radio stations before I went to law school, and also worked as a bartender and a waiter, and I dug ditches between college and when I started law school. So I had a lot of different things that I did, but then I started law school in 91 and graduated in 94. I just started my 31st year as a criminal defense attorney.
Congratulations.
Yeah.
31 years. So I know a lot of trial lawyers. I'm a trial lawyer as well. And I see a lot of them worked in the service industry. A lot of them that bartended. I did the same thing. I was a bartender and I was a social worker in Orlando. Yeah.
Yeah, it's not surprising. I do find also paper boys for some reason. I was a paper boy as well when I was younger. So I don't know what it is about that, but there is some connectivity between a lot of the trial lawyers that they were, Kathy Perry, who you talked about, my law partner, she worked at Burger King.
Mm-hmm.
Max, he worked for a furniture company. Not fast food, which I also worked at Dairy Queen. I love seeing an employee come into our office that's looking for a job, somebody during an interview. I love when they tell me they worked at McDonald's or something like that. I just love that. Some of them try to hide that.
Right. Yep. But why?
It's crazy to me.
Yeah.
That should be the headline. I worked at McDonald's.
Yeah, exactly.
Yeah.
Yeah.
One guy got it. One guy I interviewed, and he had it on his resume, picked up garbage for a garbage company. And I'm like, we had to hire that guy as an intern. So we did.
Yeah.
Love that.
That's great. So, working with people, working in customer service, whether it's retail, restaurant, business, always good things, always positive. So what inspired you to pursue criminal defense law, and how did the criminal defense team kind of come together?
So the first 10 years of my existence as a lawyer, I did dabble in a lot of different areas. And I think what happens with I'm a street lawyer.
Yep.
I'm just, people come in off the street and you try to help them out however you can. And the thing that I felt the best at and the most passionate about was criminal defense. And so in 2004, I said, you know what, whether it's a good idea or a bad idea, I'm going to stop all the other divorce work and child custody. And you got to be kind of a special kind of crazy to do that work, in my opinion.
That's tough stuff.
Some of my very good friends are family law lawyers.
Oh, yeah.
I don't know how they do it. Did you ever do that?
Yes. I was very similar. I had started my own practice in my 20s. I was working with Jason Rayom, actually. Mm-hmm. Yeah. And his partner, and I was had a couple PI cases here. I had a contract with the Julian Center doing family law, representing victims of domestic violence. Yeah. And just kind of piecemealed things, and family law was always tough.
Yeah. God bless you for doing that. I really salute. I make fun of them because I do think they have some kind of crazy gene in them to put up with the craziness. But yeah, in 2004, I just said, I'm going to stop everything else. And, that really took away a chunk of money. When I had 2 young kids and a wife, and that was for me, getting my wife involved in these decisions was very, very important when you're trying to develop a practice. You can't be lying to them. I know a lot of friends of mine that they would not want to tell their wives about how much money they were making or not making early on. When you're putting everything on a credit card to pay your staff and things like that early on, people don't know that. They think, oh, you're a lawyer, you make all kinds of money.
Right.
No.
Yeah.
No, it's not the case.
No, because it as much as comes in, it goes right out.
Yeah.
It costs a lot of money to run these places.
And just to get them in early on in your career, it's hard to get them in. And when you then cut out divorce work and custody, I was a good custody lawyer for sure, I think. And to get that kind of extricated from your practice, now you're really you're hanging yourself out there as, I'm a criminal defense attorney, please come in and hire me, because if you don't, I might end up back at Dairy Queen. So I went from just me, one person, I didn't have a secretary or anything, and now 21 years later, we have 8 lawyers, and I don't know how many employees, 20 some employees, and I still am nervous about, when you're one of the owners of the business. I have 3 other law partners now. You're just nervous all the time about whether you're going to be able to pay your people and whether you're going to be able to take care of business. And I tell my wife, we'll have a particularly good day or a good week, and I'll say, I feel like we're getting close to being a legitimate law firm, like legitimate. And she'll say, Andy, your law firm's been open for 20 years. I think you're legitimate. But yeah,
that's great.
In the law firm form that you had asked at, in 2007, I said, I want to form a law firm where we hire trial lawyers and everybody gets paid a salary, because it's very common amongst what I call street lawyers, and I say that as an endearing term, but street lawyers often, they work together in the same building, but they're not partners, and they're
like
not
an association.
Yeah, they're an association of lawyers, but they call themselves as if they are a law firm. But when you hire the one guy who's named in the law firm, the other guys are not interested in helping out because they didn't get any of the money. So I did not want to. I wanted everybody to get paid a salary, and that also took away a lot of my revenue that I could have had personally. And I don't want to make it sound I'm very happy.
Yeah.
I'm very happy about the way that I've done things, because I love going into work every day, not walking on eggshells, not worrying about, is this person that is working for me or with me. I don't really like to say they're working for me. I think everybody's working with us together. I just love that camaraderie and so forth. And so the vision of 2007, when I started the law firm, is now, starting to come true. And it's pretty, when you're at the very beginning and you're nervous about everything, about whether you're going to make it, and you get to see how spectacular all the people that you've hired and how they're doing and how the synergy works, it's really terrific.
Yeah. I was going to ask you about your team approach later on, but I love the way you guys work. It's a similar concept here, especially when when we have to go try a case, and for us, you guys just try more cases than we do. It's just natural. You do criminal defense work, but it's all hands on deck, and it's important for everyone to be that way and everyone to be invested, in helping these people, because frankly, whether it be criminal defense or personal injury or whatever, they've got their choices,
Yeah. And you need to have a lot of different viewpoints and perspectives as you're brainstorming, and I'm talking about bringing in the receptionist and everybody to come in and listen, and is this idea full of crap or is this legit? So
that's your jury, man.
That is the jury.
That's your jury.
Yeah.
More often than not, you get a lawyer on a jury. They're like, get out of here.
We've had a few lawyers on juries in the past.
Yeah.
But yeah, you really have to think that one.
Yeah. So let's talk a little bit about your practice and the kind of the philosophy of the criminal defense team.
Mm-hmm.
You guys are located right by the new CJC, right?
Yeah, we're about 0.8 of a mile from the Community Justice Center, or whatever. That's what we call it. And we also have an office in Franklin, and we have an office in Noblesville.
Mm-hmm. Yeah. So, what's the biggest difference to you between trying a case in Hamilton County versus Marion County?
Those two counties I think are pretty similar. I mean, it's very judge specific at times, but I enjoy trying cases in both of those counties.
Mm-hmm.
And in terms of jury pool, Hamilton is starting to change the demographics and the way that you try a case. It was very, very conservative for a lot of years, and we have a very big success rate in Hamilton County. We have a really big success rate, and people would ask, "How did you, get that outcome?" And I think in Hamilton, it was about jury selection.
Yeah,
it was all about reminding the jury that they have a constitutional duty to follow the law, and proof beyond a reasonable doubt, I think, really meant something to the people in Hamilton County, and so reminding of them of that constitutional obligation throughout the trial was important in Hamilton. You didn't need to do that as much in Marion. It's more of a fact-based jury often. But I hate even being general about juries because every jury is different. And,
Right.
Yeah, you could have a Hamilton County-esque jury in Marion and vice versa.
Right. How do you deal with time limitations during jury selection?
Well, I saw Jerry Spence one time. He's one of the great trial lawyers in the country. He's still alive, actually.
Mm-hmm.
And I saw this video of him when a judge was limiting jury selection to 20 minutes in first round. And for those that don't know, that's very, very little. And this was on a murder case. I had a judge do that one time.
Wow.
Yeah. And Jerry Spence said, you just need to say, Judge, I know your time is precious, and I know that you have things that you need to do, but this young man over here to my right is depending on you to allow him to talk to the jury enough that we get a feel for who's going to be fair or not. So surely you can spare some more time, another 20 minutes or an hour or something. And so I think that's one approach, is you have to talk to the judge and try to be nice about it and respectful. And the other thing is, if you don't get that much time, you got to really figure out what topics you're going to cover.
What's your issue?
Yeah.
Yeah. That's where I struggle the most with the limitations.
Yeah.
Because as these podcast episodes will tell you, I like to talk. So just get to the point.
Yeah. Well, if you're talking, what I tell my young lawyers, if you're talking during jury selection, then something is wrong.
Right.
I need to hear from the jury. So,
Right.
Yeah.
Exactly.
And guys like you and me that do like to talk, that's a struggle.
Yeah. Well, and they don't want to be there. I hate to generalize it, but a lot of them don't really want to be there.
Yeah.
So, and that's always a struggle. And then you're trying to pull these personal feelings out of them. It is and you want to establish a rapport with them so they feel comfortable with you. But when you got 20 minutes,
Yeah.
You got 5 minutes to talk to them and show them that you're a real person.
Yeah, I
It's like
usually
that.
will start with just finished a murder case up in Fort Wayne, and I think the judge was who was not a fan of mine. It's Judge Gull from the Delphi case, but we tried another murder case in front of her, Max Wiley and I did. And one of the things that, to address what you just said, how do you become a human being to them and not some lawyer that is in a suit? And I usually will try to come up with something that will cause them to know that I am just a regular person. And I'm missing a tooth right here on the left side of my mouth I was tearing open a bag of, actually it was lunch meat, and my tooth kind of went in half and I had to take it out, and I didn't have a chance to go to the dentist, and I still haven't. And so I said, something that makes me nervous is that I'm missing a tooth here. And I think I showed it to them, and I said, I don't want you to think worse of me because of that. And
Yeah.
And there's nothing wrong with it, of course, but I'm just nervous about that. And
Yeah.
And I think the judge was probably like, what would he even say that? But it is a vulnerable, you want to be as vulnerable
Yes.
as you can, as quickly as you can, to let them know, hey, it's okay.
Yeah.
Let's get real. Let's talk right now.
Right.
So
Yeah. That's so funny. Do you remember, he's passed away since, but Dave Martinet?
I know the name.
So Dave was public defender with me, and I got to try a case with him, a jury trial. It was down in domestic violence court in the old courtroom 20 in the basement.
Right.
Judge Rogers. Yeah. And it was 5 counts from D felony down. And I had smashed my finger in a door right before that. And so my finger was like this in a splint. And so I'm walking around to the jury, and it looks like I'm flipping them off. And I made a joke about it, and they loved it. We got not guilty on all 5 counts. So, but yeah, that was that. You got to do stuff like that.
No, yeah.
If you,
and it's not being fake either, by the way. It's being real. Like if it's contrived, I did that on the spur of the moment, and because I thought maybe this is a good idea, maybe it isn't a good idea. I don't know, but it is real, and I am nervous about it, and I am worried about it, and
yeah.
So,
I think any trial lawyer that tells you they're not nervous going into trial
Yes.
I mean, they just haven't tried enough damn cases.
And especially on bigger cases, but it doesn't really matter. I remember trying to driving while suspended case. I was nervous about that.
Yeah.
And the stakes were low. Nobody's going to jail on that. Still want to win.
Oh, I was talking to someone the other day about how traffic court used to be out there. Do you remember that? It was like a factory.
Yeah.
Hal Bean was out there. I trained with him, and he would line people up and just go and do a cattle call plea agreement. All right. I mean, it was crazy.
It was crazy.
Yeah.
That's why I prefer jury trials for sure. There are times when, like in traffic court, there's no jury. You could ask for one, believe it or not. I mean, if you wanted to get it out of there. But that was the old show up and see if your cop shows up. If you don't show up, then you get a dismissal.
Yeah. Yeah, exactly. So, one of the common questions you probably hear a lot as a criminal defense attorney is, how do you decide if your client should testify in a criminal case or plead the fifth?
Yeah, that's a great question. So we just finished a murder case last week, and I went to the jail to meet with the client. I'd met him before, but it was really two of our other lawyers. They were the leads on it, and they were taking it to trial. But I went in because one of the things that I do well is prepare witnesses for testimony. That's a very underrated thing about trial work, is the preparation of witnesses, especially a defendant. And I've got a way that I do that. And so Max had asked me to come down there. And so the answer to your question, one of the way to answer it is, how are they going to do?
Right.
You have to start asking them questions and figuring out, are they going to be okay or not? So that would be near the top. Another one is it needed? If it's a self-defense case, it's probably needed that they're going to testify. They're going to have to testify. Now there's experts out there, who's the cross-examination guru that I love, and I can't even think of his name right now. Anyway, he says never put your client on trial on the stand ever, and he is the man. And Posner, Larry Posner, he is a cross-examination guru. He is a trial guru. He gets paid a lot of money to go around and talk to people, and he will tell you, don't ever put your client on the stand. And he and I part ways there. I think that if you have a good defendant that is capable of getting up and telling the truth and being properly emotive about it, not improper, but genuine, the jury wants to hear that. I'll tell you one quick anecdote. This is the way trial lawyers are. We always have an anecdote, right? So we tried a jury here in Marion County a couple of years ago, and I got so frustrated with the prosecutor because she objected on my opening, and she said, he can't, unless his client's testifying, he's not going to be able to get into that. And I said, you don't know anything about my case. We're up, it was Judge Osborne, and we're talking, and she frustrated me so much that I did something that I tell all of our lawyers not to do. I got back in front of the jury, and even though she was inaccurate, I could have brought this evidence in through other means, but I didn't like her presupposing that what I was doing. So I showed me and said on opening, our client is going to testify. And, he's going to face these great prosecutors, and because he's got nothing to hide, and he's been waiting to do it. And then I sat down. I'm like, what did I just do? What?
Did you plan for that?
No, I got caught up in the moment. I got caught up in the moment big time. And then he got up and knocked it out of the park. I mean, we prepped him. Whether or not you think they're going to testify or not, you prep them anyway because you don't know what things are going to happen. And he did knock it out of the park. And then afterwards, this is the part of the anecdote that's important for trial lawyers out there that might be listening. The jury said, when you said that on opening, that we talked to the jury afterwards, they said, when you said it on opening that he was going to testify, our eyes perked up and we thought, okay, he actually might be innocent here. And that said something to me. Like in the future, I told all the lawyers in the firm, you might want to think about more seriously putting a client on, even on a borderline case, if they can do it.
Yeah.
So
I think that there's a general feeling from a lot of people that think if they're innocent, they're going to get up there and defend themselves. Just kind of like a general mindset, even if you explain their Fifth Amendment right to them, even if you talk to them about it, some people are going to want to hear directly from the person.
Yeah, the juries aren't always I think they're not lying necessarily. They're not lying. I don't think when they answer your question, what's going to happen if my client doesn't testify? How are you going to feel about that? Oh, that's his right. But in their heart, they might be thinking, man, if that was me, I'd get up there and say, I did not molest that girl, or I did not fire that gun, or whatever.
Yeah, exactly. Exactly. You talked about a case that you tried up in Allen County. Tell me a little bit more about that case. I want to talk a little bit about that.
Sure. That was the Allison Davis case, and Allison was falsely accused of murdering her husband. And it was super frustrating because it was very clear to me the first time that I met her, right around Christmas of 2023, that she was innocent. She has this great family. Not that means you can't commit murder if you come from a great family, but it was something more about, that's a piece of the puzzle, and it was something more about just her and the way that she told the story. She found her husband at the bottom of the stairs at 4:30 in the morning in a pool of blood. He had been drinking the night before. In his history as a human being, he had a bit of a drinking problem, and he would fall on occasion. And so it's right at the bottom of the stairs. She put two and two together and thought he fell down the stairs. She called police when he wouldn't, she couldn't roust him up. She called 911. They came in, and doctors thought that that the injuries were inconsistent with the fall. And that seed right there from the ER doctor then manifested itself to the autopsy doc, to the forensic pathologist, who then listened to the ER doctor, and then he started to have some questions, and then he alerted the lead detective, to those doubts. And the next thing you know, she's being accused of murder. And that was in August of 2023. In December, they finally charged her. But also what was going on in that case that was super interesting was that she had a Garmin on, a watch, and the Garmin, it showed if she was asleep. It showed what her level of activity was, her heart rate, and so forth. And the prosecution had that Garmin evidence before they charged her, and they never bothered to look at it.
Wow.
And once we subpoenaed some of the records and showed it to our expert, he's like, yeah, she was asleep is what it shows. Her heart rate was never elevated is what it shows, and she never took steps. They said that she had gotten rid of a murder weapon. The accusation was that Allison had hit her husband with a baseball bat or something along the lines of a baseball bat, hit him in the head, and that's how he died. That's what they say. The prosecution said was consistent with the injuries. And so we thought, and then they said she must have hid the bat or whatever, but the steps that she took were inconsistent with that theory as well. So you think, well, prosecutions, the prosecutor, ministers of justice, they're going to look at this evidence very seriously and then dismiss. We really believe that. And instead, they did something that was a little bit unexpected. The prosecution moved to exclude the Garmin evidence, knowing that it was very bad for their case. And then we hired the top expert on Fitbit and exercise body-worn, watches. And he testified, and as did our Purdue expert, that this stuff is reliable. And the Judge Gull, the state did not put on, the prosecution did not put one single expert on at all to say it's bad evidence, it doesn't work, it's junk. Not one. And the judge excluded the evidence with 5 words or 5 or 6 words. State's motion to exclude granted.
No explanation.
No explanation. And then at trial, when we were re-arguing it, the judge said, well, the expert from Columbia University who's testified in a million other cases about these types of devices, he was not an expert on Garmin, which is a bad precedent for her to set, by the way, because the drunk driving cases, there's an intoxilizer machine, for example. Most of the cops that testify, if not all of them, are not experts on intoxilizers. They just know the machine, just like our expert knew the machine. So the legal reasoning there even that's all that she said was he wasn't an expert. It's faulty. It doesn't make any sense really. And, but so we never got to put that garment evidence in front of the jury, which is super frustrating.
And that case was tried.
We tried that case from March 6th through the 9th. It's going to be on 48 Hours, CBS in the fall. And I always say that trial lawyers never really like to talk about their trials and tell stories about them unless at the end of the rainbow is a not guilty. Mm-hmm. There was a not guilty here. Much like your story a second ago, I was thinking, the level 6 felonies, like, yeah, there's 5 not guilties. Of course there was. I mean, yeah, most of the time when we're telling stories, we're going to be talking about our wins. And we were very pleased because Allison and her family are just the best people.
Good.
And she was in there for 18 months. She is just an awesome person. We're very close with the family.
My family immigrated here from Cuba after Fidel Castro took over, and this government took everything from my family, and that attracted me to be a lawyer. Insurance companies can be like bullies, and they have a lot of resources behind them. Give us a call here at Hurst Limontes. We are protective of our clients because our clients matter and you matter. Indiana's trusted personal injury law firm is proud to partner with the Indiana Fever for 2025, bringing the same passion, persistence, and power to the courtroom that the Indiana Fever bring to the court. At Hurst Limontes, we fight for the injured and stand up to those who can't stand alone. Just like the Fever fight every night for victory and community pride. This partnership is more than just about basketball. It's about resilience, leadership, and giving back to Indiana, on and off the court. So this season, when you cheer the Fever, remember, there's a team in the courtroom with the same winning spirit. How could they completely ignore that garment evidence? It's unbelievable.
It is. And, the prosecutors, they were nice people. I liked them. I thought they were good to try a case with for the most part. I do think that they take advantage, in my opinion at least, is they know that Judge Gull, how she's going to rule.
Right.
And so there's a lot of objections, and that's frustrating too. And there was objections burnt during, I think, jury selection. I think there were objections during opening and during closing. There was a couple of objections on their part. And that, for people that don't know, that's kind of like anathema, especially on closing, opening and closing both. You're just not supposed to, unless there's a really, really terrific good reason to object, you don't object.
Yeah. Yeah. So
I was objected to, and during my closing, and I was telling I had told what I would say is a pretty compelling story. I'm a storyteller on closing, and the reason given for the objection was that he's scaring the jury. And I'd never heard that. And I was talking about how important reasonable doubt was at the conclusion of my story. And so I just viewed that as a badge of honor, that the objection that I was trying to scare the jury was more really I was being effective in arguing to the jury.
Exactly. So that's usually when you draw an objection during opening or closing
or cross big time. When you're on the I call it the rhythm of yes. I thought about writing a cross-examination book called The Rhythm of Yes. When they're in the yes mode, you got a witness up there and they're just yes, 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 and you're telling the story through cross-examination.
Yeah.
Then that's the time to object. If you're a prosecutor, you want to get us out of the rhythm of yes.
Right. Yeah. That's so funny. I love that. The rhythm of yes. Andy, what advice do you have for young lawyers interested in doing criminal defense or draw work?
Sure. First piece of advice is don't expect to become rich. When you get out of law school, you have all these high ideas of how much money you're going to make. And that's not to say, personal injury lawyers, they do great work and they help a lot of people out, and they do well, a lot of them. You're not going to be making that type of money as a criminal defense attorney, generally speaking. So make sure that you have the right level of passion for this work of criminal defense. You can make a great living, by the way, too, but it's not going to be, if you think you're going to be able to have, a place in France and, in a couple of years, that's not going to happen. But you do need to have a real devotion to the craft of what we do. Don't also take this work for granted in terms of, okay, I've got a little DUI case, I'm going to just plead that thing out. Look and do the work. That's another thing. It's real easy, especially when you've been doing it as long as I have been, to think, okay, I can just kind of mail it in on this case because I know how the end of this book's going to be written. It's going to be a plea. I'm going to get this type of outcome. And I see over the course of my days, I've seen very experienced lawyers who kind of dial it back and dial it down as they get older, and they're not in the courtroom as much and they're not trying cases as much. And I don't ever want to be that guy, because this is not like falling off a bike and getting right back on. If you're not in the trial game, if you're not trying cases regularly, some of those chops that you have developed over time, they atrophy. And that is a problem. So you need to be in it for the long haul would be another thing, and try those cases that need to be tried.
Yeah.
So
yeah, it's funny. I did not anticipate being a criminal defense attorney when I first started, and I stepped into the courtroom, and I was in court 19 with Becky Pearson Tracy.
Yes,
and I loved it. I took to it like a duck to water. I did. It was fun.
Yeah, a lot of action in that court.
Yes. I mean, you'd see 50, 60 people in a day, between you and your court partner.
And if you wanted to try a case a week, you could in that court.
Yeah.
Absolutely.
You could. Yeah. So I tried my first jury trial a couple months after I became a lawyer. It was a 2-count disorderly conduct and resisting by force. My client was a 67-year-old woman with fibromyalgia who I just told the jury, I was like, I don't think she's even physically capable of doing it. So
not guilty on that.
Right. Not guilty, split count. Guilty on the disorderly because she insisted on testifying. Insisted. It was her first offense, by the way. She turned down a diversion. She turned down a diversion and with 10 hours of community service. And the case had to go we went to jury trial. And so she was acting disorderly in the courtroom. She went up to the stand, and the prosecutor just asked her a simple question, what's your name or something. And she goes, "You're a real asshole, aren't you?"
Yeah, the disorderly. Well, it's great that you got the split verdict on that with that type of attitude. But it's funny because how long ago was that? 20 years ago?
That was in 2007.
Yeah.
Almost 20 years ago.
Yeah. So it's funny that it's like a golf shot. There's things you're not going to forget. By the way, there's a lot of things that we do forget. Also, I'll run into clients that I spent a week trial on 15 years ago. One of them just came into my office on Friday. I had not seen this lady forever. And I looked at her and I thought, I think I know who that is. And of course, they know who you are because you're their lawyer. And Andy, I love you. I just wanted to stop by and say hi. I haven't seen you for so long. She kissed me on the cheek. And I'm like thinking, who is this woman? Who are you? And ultimately, by asking the right questions, I figured out who it was. And it was great to see her again.
Yeah. I had that same thing last week. Lady came in with her boyfriend. And she was like, "Do you remember you helped me 15 years ago or something?" I couldn't recall. So.
Yeah, it's again, we don't. It's an honor to do what we do. Big time is, and that's part of the proof of it, isn't it? And is that people that you represented 20 or even 30 years ago, they come up to you and they'll say very nice things like, "You've changed my life. You gave me freedom," or whatever. And you may not even remember that person, but you had that type of impact on their life. And I always say to people, being a criminal defense attorney, it's a sexy thing for a lot of people. They think it's really cool and interesting. And it is, and to say it isn't would be disingenuous. However, the guy that does collect the garbage, that's an important guy too. And the guy that, cracks your back as a chiropractor and solves the pain level there, he's an important guy too.
Yeah.
Or lady. So I don't ever want to overvalue what we do, yet it is a unique job that does have immense impact on people's lives.
Yeah. I mean, it's, I tell people sometimes it's not a career, it's a calling, and you're pulled to it like gravity.
Yes.
So, well, let's change gears, and we're going to talk a little bit about this Delphi case. All right. And let's start from the very beginning. When you were first brought onto the case, what were some of your initial thoughts?
Well, I had heard of it, and I knew that 2 young girls had been murdered or found in, I shouldn't even say that. I really just knew that 2 young girls had been found in the woods or something.
Yeah.
And I didn't really know I presumed that they had actually been murdered, but I didn't know that. And that was about it. I didn't really know a whole lot more than that. I had a fraternity brother from Delphi, so I knew about the town of Delphi. I wasn't really sure where it was. I thought it was up north. And so when I entered my appearance, and the way that happened was Brad Rosie, my co-counsel, lifelong friend now, he did not know me. I did not know him. He called me. I had just finished an LWOP, life without possibility of parole murder case, which I had just finished that 2 or 3 days before.
Wow.
And so now I had some time maybe to think about taking on a higher profile murder case. That was a high profile case. As a side note, I got a great deal for him. And while I was in the Delphi trial, I got a note or a email that my client had been released. He was accused of burning. We called it the Burning Man case in the office because he was accused of burning a guy in a car.
Oh my!
And there was video of some shadowy figure, and there was some evidence out there. They filed an LWOP, and so he's facing life without possibility of parole. And we knocked it down to, I think it was a level 3 or something, and he got 2 years of executed time, of actual time. So while I was in the Delphi trial, the case that ended, that allowed me to get on to Delphi trial, that defendant was released during the Delphi trial, which this was kind of an interesting way to, in some ways, come full circle. But because that case had ended, Brad had called and said, you don't know me, I don't know you. I've heard your name a few times from people as a, whatever, passionate guy, trial lawyer, and would you be interested? And I said, sure. I just finished a case. And then Judge Gull called me because she had to approve of it. And
was that your first experience with her?
It was. I knew Judge Gull's daughter, Tina, who's a nice person, a good prosecutor. And Tina, so that was a topic of conversation. I know your daughter, and we had a nice conversation, Judge Gull and I did. And then she said, yep, if you want on, you're on. I said, and actually, it was more like, we're really looking for people that have experience. Would you be willing to do it? And when a judge asks you to do that, you say yes. And so,
yeah. And when we were talking earlier, you mentioned did you think it was going to turn into what it did?
I had no idea what I was about to walk into, and I still don't, to some degree. I still have to process everything that has happened over the last 2.5 years. But at the time, my first clue that this was bigger than I thought that it was, far bigger, was once I entered my appearance on the case. So probably an hour or so after Judge Gull talked to me on the phone, I went over to my paralegal, just as I would on any other case, and say, hey, go ahead and enter an appearance on this case. So in Indiana, for those who may or may not know, there's a thing called Odyssey, and it's available to the general public. When you and I first started, there wasn't anything like that. So you would never know unless you went to the courthouse and actually dug in and said, who is on this case? Can I ask you to dig that file up and tell me who's on this case? As a journalist, that's how you would know. Nowadays, for the last 10 years or so, it's once you hit send, it goes out to anybody around the world that is paying attention. And so what I found out later is a lot of people were subscribing, and there's a way that you can you can get tickled on your iPhone or whatever when new pleadings or an appearance enters. And so within, I'd say 10 minutes of entering my appearance on Richard's case, I was getting calls from ABC, National News, CNN, New York Times, Washington Post, that kind of stuff. And then I thought, oh, this is going to be a little bit of a bigger case than I thought, or a lot bigger. Yeah.
Let's backtrack a little bit.
Mm-hmm.
Tell me, for those that are listening that maybe don't know much about it, I think that'd be hard, but don't know much about it. Tell me a little bit about, what happened here, what the allegations were.
So Richard Allen, Rick as I call him, was accused of, in the middle of the day on February 13th, 2017, walking across a bridge, walking on the other side of the bridge down a sloped hill, a pretty significant slope, then down 70 feet or so to the bottom of the ravine under the bridge, across a river that was cold and moving. There was a lot of water there. February, and then going across the river, and then in the space of, by the time we got to trial, from the state was saying that Richard accomplished all of this by himself. He took two girls, kidnapped them. Their claim was he did it by holding a weapon on them, a gun, marched them across the river, somehow was able to keep both of them together, got them across. He was freaked out, the prosecution says, because he saw a van, and their claim was that he had planned to rape them, but because he saw a van, there's a little side road that goes under the bridge on the side where the girls were abducted. So he walks across the bridge, goes down a hill, and there's a road that he would have had to cross also at the bottom. And they're claiming that our claim is, by the way, just so it's clear, Richard never crossed that bridge. That's a fact. But they're claiming, the prosecution was claiming that when he got across the river or the creek, it's called Deer Creek, but it's bigger than a regular creek, he looked across the creek from where he had just come, and on that little access road, he saw a van, and that caused him to freak out, is what they claim. And then he went up and killed the girls. And
that's what they're alleging.
That's what they're alleging. That he freaked out, killed the girls by himself, then walked up a hill on that side, which right where a cemetery was, and then got on the road. And then after killing these girls, he walked on this a road that's driven by a lot of people. And he was in the middle of the road walking, or close to the middle of the road, with blood on him and so forth. Just things that just didn't happen and don't make sense. And that he did, one of the keys to it is that the state, by the time the trial was over, the window of time that he had to accomplish all that, the video, there's a famous video that I should mention. There's a famous video that was taken at 2:13 p.m. and nobody disagrees on that time, 2:13 p.m. And they're saying that the deaths occurred by I think it's 2:31 p.m. So that Richard had to accost the girls, if what the state's theory is correct, accost the girls at 2:13, go down a hill, go across the river, kill one girl, then kill the other girl, all in about 17 or 18 minutes, all by himself. But here's the kicker. The one girl, and everybody knows this, and it's tough to talk about these things because I don't want to just dehumanize these girls, but they were human beings. They were lovely people by all accounts, and they had a bright future ahead of them. And I don't want it to sound coarse in the way that I'm describing them. And that's been one of the tough things about the case is, how do you approach that?
Right.
But anyway, Richard was so freaked out, if the state's theory is true, that he took the time to undress one of the girls, or she undressed one of herself, and then he put the clothes of the one girl of the one girl onto the body of the other girl.
Okay.
So because that's the way that the girl was found. Both girls were at some point in time, according to police, were in a state of undress. And Richard, who they claim was freaked out, in 18 minutes, not only did he do all the killing, but he also took the time to dress the other girl. And then there's no DNA allegedly found at the scene. The scene is cleaned up. But then also at the very, very last thing that this person probably did, whoever the killers were, they placed sticks on the girls in a very unusual pattern, especially on one of them, but on both of them. And therefore, the police immediately suspected that this was a Norse pagan. It was possibly a cult or witchcraft, or Norse paganism was the most likely scenario. And so that started to begin. That was investigated. Norse paganism as a ritualistic killing was investigated very early on, within 1 to 2 days, if not immediately. We know that because of emails that we subpoenaed from the state police to the FBI.
Is that the Odinism cult theory?
Yes.
I want to talk a little bit more about that. As far as, is there a history of that type of behavior, that group being in that area, or just the general area?
Yeah, there's Odinism or Norse paganism generically. Kind of Norse paganism is like the umbrella, and then under it would be, there's Odinism, and there could be other offshoots. But at least in Delphi, there was a group of people that practiced Odinism, Norse paganism. One of those people was from Logansport, but he would come to Delphi every Sunday for a ritual at another Odinist's house
In
Delphi, minutes from where the girls were found. And this person that would come from Logansport, which is about a 20-minute drive, and would be in Delphi every Sunday for a number of months before the killings. This person had a direct link to one of the victims. It was his son dated one of the deceased, Abby. So there was a direct in that. So when they saw the sticks on the bodies, they thought it's Odinism, and then they see that the father of one of the victim, of the boyfriend of one of the victims, was an Odinist. Then they started investigating this person for potentially being involved in the murders, and that happened within a day or two.
And how does this person stack up against Richard when you look at them, let's say, physically? The appearance wise?
I would say that's a good question. I would say Richard was, he is a middle-aged man, out of shape, with a dad bod, okay?
Yeah.
The person that I'm talking about, Brad Holder is his name. And I don't mind saying his name because he was a suspect in the case, and that's those are the facts. I'm not going to say anything. I have no idea whether Brad Holder or any of the other people named in the Franks memo, which I'm sure you'll talk about here, whether they had anything to do with this. I can only say what the evidence shows, and and Brad is many Odinists are into bodybuilding, or I don't know, weightlifting. I wouldn't say it's bodybuilding. It's more like putting on bulk.
Yeah.
And they have beards. And so in that regard, Richard, Rick did not look anything like Brad. These people they bulk up and they go to the gym a lot. And Richard was definitely not in that camp. So
let me ask you about you mentioned a video, and if you watch the news, obviously they talked about the bridge guy.
Yes.
Yeah. Tell me a little bit more about that.
Well, Libby's phone was found. This is just a very curious thing. It was found under Abby's body. Libby was the older and Abby was the younger.
Mm-hmm.
And Abby had the clothes on her. She had Libby's clothes on her. Under Abby's back, just curiously, was a cell phone. And on the cell phone, as it happened in trial, it came out that the cell phone stopped moving. I believe it was at 2:31 p.m. And so presumably at that point in time, it was under Abby's.
She let that evidence in?
She did let that evidence.
She won't let your Garmin in?
Yes. Yeah, there was some Fitbit info that was allowed in that actually talked about steps and things that were important, and that was allowed in. Now, to be fair to Judge Gall, and I try to be fair, I really do, we did not object to it because we felt that the Fitbit information helped us out, the data.
Yeah.
And so at 2:31, the phone stops moving. Now, there's explanations. I don't think the phone was there. I don't think those girls were there. I think the evidence shows that the girls were not there at 2:13, 2:31. I think the bodies were brought there later. The girls were brought there later. But that's maybe a story for a different day. I don't know. But the question was the bridge guy video. So on Libby's phone was somebody had taken, we believe it was Libby, had taken video of a man on the bridge that looked like he was following behind them. And it's about a 43-second video all in all. The police released a few seconds of that early on for purposes of generating lead calls.
Yeah.
And so everybody in the world that was paying attention to the case knew what that video looked like. They didn't know the full video until trial, but the video shows a guy kind of meandering across the bridge, and they just everybody presumes the bridge guy was the killer. I got to tell you, I don't know that that's the case. It seems likely that that person, who was not Richard Allen, in our opinion, but that person probably had something. I don't even like saying probably. I just don't know. It might have just been a red herring that guy had nothing to do with anything. One of the things I'll tell you that I think is super important is we call it the 207. The 207 is a photo that's taken on Libby's phone also that was found under Abby's body. And it's a Snapchat photo that was sent out to all of Abby's and Libby's friends, or not all of them, but many of them. And that was taken at 207. The vantage point of that photo was taken from where the girls had crossed earlier and from where they say Richard Allen had crossed. So you're looking down at the other end of the bridge, not where they were abducted, but the viewpoint was from where they would have been coming.
Yeah. And
in that 207 photo, what's so important, and we didn't do a good job at trial of really highlighting this, and this is one of the many areas of things that I've been upset about related to my performance and how we could have done better, but is really taking advantage of the preposterousness of Richard Allen, 5'5" Richard Allen, running across this bridge, this rickety bridge that had holes in it. I mean, it was super dangerous to the point that Doug Carter, the superintendent of state police, very histrionically will talk about how it's so, you have to crawl across that because it's so dangerous, and that's what he did. And of course, I was not allowed to talk about that at trial because I was the point, and I'm famous for like going off in different tangents. I'm going to try to take these one at a time. The reason that 207 photo is important is it's where you see Abby. What you don't see is behind Abby, you do not see anybody. Richard Allen, right, the actual guy that's on the bridge at the end of the bridge, you don't see any of that. And Abby is, I'm going to guess, we've guessed maybe close to halfway across the bridge at that time. And so if the state of Indiana, the prosecution is claiming Richard Allen followed her on the bridge, he ain't on the 207 photo.
He would have been on that photo.
Yeah, he would have been on there, or he could have, I suppose if you want to say, well, no, he maybe had hidden in the woods at that end of the bridge and then got on, and then he'd have to run. Okay, well, let's dismantle that right now. First of all, again, Doug Carter said that the bridge was so fraught with disaster, potentially with all these holes and so forth, that he felt like he had to crawl across there. it was a kind of a rite of passage among those that lived in Delphi to go across this bridge. It's one of the things that teenagers would do, when you're young and you feel impervious to danger, you're going to take these risks. Well, Doug Carter, understandably, and others would not want to take that risk. Mm-hmm. So you walk very, very, very slow.
Yeah.
And if you're walking at all, if you're not crawling like Doug Carter says. So the reason that's important is by the time Abby and Libby would have got to the end of the bridge where they were ultimately abducted, presumably abducted, Richard Allen would have had to make up for that time because he's not in the 207 video, so he would have had to come out of hiding from the woods at that end of the bridge, get onto the bridge, and then haul his butt. He'd have to run hard. This is a guy who's smoked a pack of cigarettes a day. He's a middle-aged guy with a dad bod, okay? I mean, this is not a guy that would be able to accomplish that. Plus, he has very tiny feet, okay? That was one of the first things I noticed about Richard Allen when I met him was, man, he's got really tiny feet. The type of feet that on these kind of gaping holes could get caught, And so there's that. Yeah. And could he make up for that time in such a short period of time? Because that 207, that means 6 minutes later, Richard Allen is there. Okay, is right near the girls at the other end of the bridge. Okay, so there's that. Well, then what does the bridge guy video look like? Is this guy huffing and puffing and panting with his knees? Listen, I'm a little older than Richard, not too much older, but I'm a few years older than Richard. Going up a flight of stairs, and I'm in terrible shape, so there's that. But going up a flight of stairs when you're 40, 45 years old, and Richard wasn't a workout guy at all. He's not huffing and puffing. He's not bending over. I'd be like panting, but Richard is casually walking, see? So I think what the evidence to me is very clear of what happened at that end of the bridge. I think there was at least one, probably more than one person already at that end of the bridge where the girls were abducted, and they were down hiding on the side of the bridge. There's little areas that you could hide. And then when they saw the girls walking across the bridge, one of them got on the bridge, walked toward the two girls, and then as he passed them, he turned around and followed them not very far away, closely. And that's that's what caught Libby's eye.
That's bridge guy.
That would be bridge guy.
That probably came at them as they were walking.
Yes.
And then turned around, and then maybe she was like, this is weird.
Yes. And that makes a lot more sense as to why she would take the video. I mean, if Richard had been running, if that's what their claim is, that Richard he would have had to have been walking at a very fast pace, and that would have caught their eye too. But if that were the case, he would have been panting and doubled over and not walking casually.
Right.
And so the 207 photo is something that's very important about this case. It was not really explored as much as it should have been. One of the jurors did ask a question, could it have been somebody at the other end? And I thought, okay, they're on to something here. But then at trial, I wanted to ask Doug Carter a line of questions about that during my cross of him. And the judge really reined me in. I never understood why. I still don't understand to this day. Why did Judge Gall rein me in? The transcripts are going to be out soon, and you're going to hear the sidebar. I wish I would have fought that more. I wish I would have fought more about why am I not being allowed to talk about a number of areas, like why the FBI were kicked off the case. I was not allowed to talk about that. There was different opinions on that from different people there. So that goes to credibility. I should have all been able to be talked about. So that was one area I was not allowed to talk about. I was not allowed to talk about Doug Carter crawling across. That was going to then lend itself to a series. I called them chapters in the cross-examination. Larry Posner's method is the chapter method. And that would lend itself to chapters where Doug Carter, you had to crawl across there. So you would never have run across there. And, you're kind of, if you had to run across there, you would have been panting. There could have been all that kind of stuff. And you're telling the story through cross-exam. But I was I was shut down by the judge on the sidebar. Still to this day, it didn't even make sense to me. And I'm going to be embarrassed about some of these sidebars because I was trying to be nice. And I wish I would have fought back more on these sidebars when we were getting shut down about things.